Good morning, everyone. The LLM Mercantile program will be presented for the first time from 2021. There are also currently 4 modules in this program with a mini dissertation. Before I'm going to give you a background to the 4 modules, let me just start off with the following scenario. Is it possible for a foreign company to conclude a contract with a South African company? And the answer is quite simple, yes. If you know the requirements for a valid contract, then this will not pose any problems to you. Is it possible for a foreign company to conclude a contract with a state-owned company, a South African state-owned company? And this problem is also not very difficult because if you know the requirements for a valid contract, it will also pose no problems. The next one is a little bit more complicated. Is it possible for a foreign company to conclude a contract with the Republic of South Africa? In other words, is it possible for a foreign company to conclude a contract with a state? Now, in this regard, there are different views, and the first view is, for example, Professor Dugard, who wrote a textbook on international law, a South African perspective, and he is simply of the opinion that it's quite possible for a foreign investment company to conclude a contract with a state. Other scholars or attorneys or advocates will simply say, no, it's impossible because the Vienna Convention only allows for 2 or more states to conclude a contract with each other. In other words, bilateral or multilateral treaties. To a certain extent, I agree with Professor Dugard because in South Africa we have the Protection of Investments Act, and the Protection of Investments Act clearly defines who is an investor, for example, a company. And the Protection of Investments Act also stipulates to you the requirements in order to resolve a dispute between a foreign investment company and, say, for example, a state. Besides the latter, if it's possible for a foreign investment company to conclude a contract with a state, it's also very important to focus on the clauses of that treaty or contract for dispute resolution procedures. Sometimes the treaty will simply say that you must submit a complaint to the international international organization to resolve your dispute. And that can either be in America or in Africa or in Europe. And sometimes the treaty will simply say that you're not allowed to approach any remedies in domestic law in order to resolve disputes between the foreign investment company and, say, for example, a state. With that scenario in mind, the following 4 subjects are very important because to a certain extent, they are linked to this scenario. The first subject in the LLM Mercantile program is corporate law and corporate governance. Now, we all know what is corporate law, company law, and you're going to focus on the Companies Act 2008. And as an example, we're going to focus on board meetings, shareholder meetings, and also director delinquencies. And then another aspect is corporate governance. Why is corporate governance so important? Well, it's regulated by the King IV report. However, the King IV report is simply a voluntary document. In other words, there's no mandatory requirement to implement the provisions of the King IV report, say, for example, to the Companies Act. However, we are seeing currently in the high courts in South Africa that more and more judges are referring to the King IV report in order to understand difficult company law concepts. For example, director delinquencies. In the corporate governance King IV report, there's a clear definition of ethics. And in brief, ethics is simply saying what is right and what is wrong. So if you apply the definition of ethics, say, for example, to director delinquencies, you'll have a better understanding how to apply the Companies Act from a South African perspective. Second subject is financial markets and securities law. Now, financial markets, very briefly, you have a secondary market and a primary market, and securities deals, for example, with shares and debentures. So a share and debentures are simply referred to as securities. So a newly listed company on the JSE, for example, will issue a prospectus to investors. And an investor will read the prospectus in order to make an informed decision whether to buy shares in that particular listed company. That is referred to as the primary market. The secondary market deals with where one shareholder simply sells his shares to another shareholder, and there are also statutory requirements that you must comply with in that regard. The third subject simply deals with international trade and investment. Now, international trade and investment is an extremely interesting subject. You're going to focus on the World Trade Organization. You're going to focus on the disputes settled by the World Trade Organization. And the World Trade Organization, currently, there's approximately 193 members. So in other words, to be a member of the World Trade Organization, you must be a state. The World Trade Organization will, for example, tell you what's the rights and duties for individual states. And what is so important about international trade is that a country is not really sovereign. In other words, a country cannot simply decide what it's going to do in its own economy. You cannot live in isolation. We cannot exist in isolation. We need other countries for trade purposes. The last subject is the contemporary intellectual property law. Intellectual property law is a very interesting subject and currently a little bit undeveloped in South Africa. You're going to focus on copyright. We all know copyright. For example, plagiarism, which is a big problem. Then you're also going to focus on trademarks and patents. Now, to illustrate to you what is a patent, a contemporary example is simply medicine. In order to register a pill or to protect the intellectual property associated with a pill, it's possible to register a patent based on the chemical composition of a pill. So for a fixed number of years, you will have intellectual property linked to that pill. And as a manufacturer, you can produce your pills. And the moment when that patent is about to expire, it's possible to change the chemical composition of that pill once again and to register that new formula as a patent for future trade in South Africa. So that's my contribution to LLM Mercantile Law. Thank you.
Well, Dr. Niels, that was impressive, to say the least. We have two questions here. One is, this is a brand new qualification you've mentioned. It's straight off the shelf from the year 2021.
Absolutely correct.
So what kind of methodologies do you expect in the mini dissertation part of the studies? It seems to me there's a very strong focus on contextual law and an eye for detail. Are we talking content analysis, discourse analysis? What would be the methodologies you focus on?
Well, the methodologies will be, for example, a comparative study. So, for example, between South Africa and other states or other nations, for example, in your mini dissertation. It will be the normal research methodology. In other words, it's a textbook, case law, legislation analysis of the particular law in question. So in that regard, it's not empirical to some extent. Thank you.
The last question is perhaps in bridging the gap between what is voluntary or recommended, such as you've mentioned, the King IV report, and what is statutory and can be applied within the international environment. How is that a contentious issue? I know that of late, there were many discussions on intellectual property and copyright. What can you stand up within the international arena and fight for with legality behind yourself?
If I understand you correctly, you're asking what's the influence of the King IV report on. Now, the King IV report is a voluntary document. It contains approximately 7 principles, and these principles are very goodly explained in the document. So if you are struggling with a specific question in the law, say, for example, the Companies Act, and you can focus on the King IV report, where the King IV report will give you a lot more detail how to solve a particular problem in question. You must remember that corporate governance deals with social problems and also with environmental problems. You have to have a sustainable economy. You have to keep in mind that you cannot do any harm to the environment. You must keep in mind that you cannot do any harm to your social relationships within South Africa. So that's very important, the King IV report.
Dr. Killian, one last question. It's about the mode of delivery for mercantile law. How is the degree presented when it comes to mode of delivery?
The mode of delivery, there will be scheduled classes on a Friday or on a Saturday. It will be, for example, by means of Zoom. There's no need for you to be present in a specific class and to listen to a specific lecturer explaining to you legal problems. You can sit in your house, for example, and you can just log in to a specific Zoom link, and there you will be able to get the whole content as described to you by the lecturer.
Ladies and gentlemen, that was Dr. Niels Killian on mercantile law. Thank you very much, Doctor.